Basically Dad. Welcome to the channel. The First Amendment of the Bill of Rights states, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. The First Amendment provides protection of 5 basic rights: speech, press, petition, assembly, and religion. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The constitutional freedom of religion is the most inalienable and sacred of all human rights. Thomas Jefferson. America's history with freedom of religion begins in the early 1600s, when pilgrims came to America aboard the Mayflower in search of religious freedom. The First Amendment to the United States Constitution says that you have the right to practice your religion or no religion at all. Religious freedom is more than the freedom to worship at a synagogue, church, or mosque. It means people are not required to go against their core values and beliefs in order to conform to culture or government. Religious freedom protects people's rights to live, speak, and act according to their beliefs, peacefully and publicly. It protects their ability to be themselves at work, in class, and at social activities. There are 2 basic rights protected by this portion of the First Amendment to the Constitution. The Establishment Clause of the First Amendment prohibits the government from promoting religion, which is why we don't have an official state-sanctioned religion of the United States. The Free Exercise Clause of the First Amendment protects your right to worship or not to worship however you choose. The government cannot penalize you because of your religious beliefs. The Establishment Clause. Historically, the Establishment Clause outlaws state-sponsored churches such as the Church of England, but it also prohibits the promotion of religion by the government. Thomas Jefferson famously said that when American people adopted the Establishment Clause, they built a wall of separation between the church and the state. In 1971, the Supreme Court ruled on one of the most important cases in American history. This case, Lemon v. Kurtzman, ended with 3 concrete prongs that determine whether any government act or policy violates the Establishment Clause mentioned in the First Amendment. These 3 prongs are referred to as the Lemon test. For an act or policy to be constitutional and Establishment Clause compliant, it must have a non-religious purpose, it must not end up promoting or favoring any set of religious beliefs, and it must not overly involve the government with religion. The Supreme Court has used the Lemon test numerous times to rule over religious cases. In 1961, the Supreme Court listened to a case about a Maryland requirement that candidates for public office must declare a belief in God to be eligible for the position. This requirement put government in the position of promoting religion by giving preference to candidates who believed in God at the cost to those who did not. This requirement was found to break the second prong of the Lemon test, and therefore it was found to violate the Establishment Clause and be unconstitutional. In 1980, the Supreme Court found that a Kentucky state law mandating the display of the 10 Commandments in public school classrooms broke the first prong of the Lemon test, when the court found that the law did not have a non-religious purpose. This law violated the Establishment Clause and was unconstitutional. The Free Exercise Clause. The second clause, the Free Exercise Clause, protects your right to worship as you please. The Free Exercise Clause protects an American's right to hold any religious belief, and it also protects their right to act on behalf of those beliefs. The Free Exercise Clause covers all people equally: Christians, Jews, Muslims, agnostics, and atheists. Because of the First Amendment, people of different faiths, worldviews, and beliefs can peacefully live together without fear of punishment from the government. Attempts to violate religious freedom is an attack on individual liberty and human dignity. It assaults the very foundation that has made America free. In 2020, during the COVID-19 pandemic, New York Governor Andrew Cuomo put limits on churches, synagogues, and other houses of worship, ruling that they could only have 10 to 25 worshipers inside. The Supreme Court placed religious freedom before pandemic precautions and decided that the governor's actions were unconstitutional. Justice Gorsuch said, "Even in a pandemic, the Constitution cannot be put away and forgotten. The restrictions at issue here, by effectively barring many from attending religious services, strike at the very heart of the First Amendment's guarantee of religious liberty." In 2010, the Affordable Care Act became American law, mandating that corporations must provide health insurance for its employees. This included a requirement that corporations must pay for contraceptives. The owners of Hobby Lobby argued that this went against their Christian beliefs. In 2014, the Supreme Court ruled that the government violated the Exercise Clause by requiring the owners to go against their religious beliefs. The First Amendment of the Constitution has restricted the government from violating citizens' religious freedoms on matters including polygamy, animal sacrifices, and working on the Sabbath. It protected a cake baker from being forced to provide his services for a same-sex wedding that violated his religious beliefs. There are limitations to religious freedom. The 1963 Supreme Court case in Sherbert v. Verner helped to develop a test to clarify the limits of free exercise. The Sherbert test asks 3 questions. First, does the person have a claim involving a sincere religious belief? And does the government action place a substantial burden on the person's ability to act on that belief? If the answer is no, there is no violation. If the answer to both of these questions is yes, then you must ask, does the federal government have a compelling interest to limit freedom in order to protect the common good and limit people's ability to harm others? According to the Sherbert test, if the answer to all 3 questions is yes, the government has the responsibility to restrict religious freedom. Cases involving drug use during religious ceremonies, human sacrifices, and people using religious freedom as justification for Jim Crow laws have all been restricted after passing the Sherbert test. Many constitutional scholars, and even the Supreme Court, argue that there is a conflict between the 2 religious clauses in the First Amendment. The argument goes like this. The Free Exercise Clause requires the government to give special accommodations to people in order to protect their exercise of religion, but it is a violation of the Establishment Clause for the government to give special accommodation because of religion. In this argument, we have a First Amendment in conflict with itself, the Establishment Clause forbidding what the Free Exercise Clause requires. Do you see the Establishment Clause or the Exercise Clause as the more critical portion of freedom of religion? Why? When have you seen freedom of religion violated? Could you rewrite the freedom of religion portion of the First Amendment in a way that would settle the conflict between the 2 clauses? Do you think the Constitution's freedom of religion protects or punishes one religion more than others? Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Please like, subscribe, and share with a friend. It's so nice when you share. Thanks for visiting. Classically, Dad.